Lord Brown Wilkinson once said, "In truth, judges make and change the law. The whole of common law is judge-made." We will be talking about common law system and how judge-made law works and discussing relevant cases and statutes. In 1066, when William the Conqueror took the throne, he was met with contradicting and varied legal system from different areas that he was governing. After surveying and eliminating schemes that are unreasonable, the higher powers worked on assembling a system that would later prove to revolutionize the legal system. It took 2 centuries for the process to get drafted and finalized. In 1250, the common law system was created. During this colonial era, this system was then enforced in multiple areas of the world, namely the majority of the African continent, India, Singapore, and importantly, Malaysia. The common law system is based on the principle of stare decisis. Stare decisis is Latin for let the decision stand. This means that cases that were decided before would have power that consequently impacted cases that came after it. When discussing one case, judges in those cases can find other cases that are either binding or persuasive to the case that are in progress. The reason behind this system is to ensure consistency and control the amount of absurdity there would be in the justice system. Ratio decidendi is when a case is binding to another case that leads to the case's result. More often than not, these cases are detrimental to the decision rather than being mere decision themselves. On the other hand, we have obiter dicta, which are cases that act as supporting arguments along the way of the case decision. The courts that the court that the cases were held in would be important to how impactful the case's decision The court that the cases were held in would be important to how impactful that case's decision would be as well. The order of the judicial system from the least binding to the most binding would be small claims court, magistrates court, sessions court, high court Malaya, and high courts Sabah and Sarawak. Sharia court exists within the realm of high court Malaya and the other lower courts. And they all come together, and these are the higher courts. So we have the Court of Appeal and Federal Court. Federal Court is the most binding court out of them all, and decision from the federal courts that would lead to binding power to all courts under it.
Firstly, we'll be talking about the history of law. Common law. During the reign of King Henry II, many customary laws were replaced by new national ones, thus declared, quote, common to all, end quote. Curia Regis was where common law was set up. As royal judges went to provincial towns and brought the law from Westminster wherever they went, applying them in both civil and criminal cases, which then resulted in common law applying almost everywhere. This developed a centralized judiciary, which caused the declaration of common law by judges. The English legal system began operating on procedural remedies, but as years passed by, substantive rights continued as the court's function and seen as primary. In the late 19th century, English common law then would primarily be developed by judges. Secondly, judicial precedent. Common law is law declared by judges that had derived from custom and precedent. The doctrine of judicial precedent, in which principles applied in previous courts, known as, quote, courts of record, end quote, or, quote, stare decisis, end quote, a legal principle that must be obliged and respected by judges. Moreover, the doctrine provides an outline for judges as to what must be held in present cases. Thus, courts must follow rules established by a superior court. Moving on, William Blackstone argues that judges declare law instead of making law. In the commentaries, Blackstone further argues that the judge's job is to determine the law, quote, not according to his own private judgment, but to known laws and custom laws of the land, end quote, and that they are to not make new laws, but instead maintain and expand on existing ones. This provides the idea that judges do not make new laws, even when there is an overruled precedent. They are merely declaring law used in an earlier court is wrong and correcting it. Next, the development of statute. Edward I had been an important influence on the law of Middle Ages, whereby his civil legislations amended the unwritten common law, which then remained the basic statute law for centuries. Parliament today creates new laws or make changes to existing ones. These statutes function in setting the basic principles of the legal system. And there are several stages as to the development of a statute. Firstly, statutes are first a legislative proposal by the government ministry. It is then drafted to become a bill by the Parliamentary Council. Third, it is read and consulted by the House of Commons, House of Lords. This is where consultations and amendments are made. Then granted a royal assent from the monarch to enact legislation, and the Royal Assent Act 1967 had outlined that the royal assent would be signified by the Lords Commissioners on behalf of the monarch.
Start. Now I'm going to talk about statutory interpretation. The United Kingdom's constitution is an unwritten rather than a written text. Statutes of law, often known as legislation, are the written laws that comprise the unwritten constitution of the United Kingdom. Legislation is another term for a statute of law, and members of the Parliament in the United Kingdom design these statutes and pieces this legislation together, while the other arms of the government are responsible for putting them into action. Because these statutes and laws are not always plain and unambiguous, it is the court's job to interpret and in complying with the most recent legal developments and acknowledge the statutory interpretation criteria. The process of interpreting and applying legislation is known as statutory interpretation. The court has evolved three basic rules of statutory interpretation and one general approach. The literal rule, the golden rule, and the rule of mischief are the three basic rules. The golden rule. The golden rule, one of the three most basic principles, is a rule that used in statutory interpretation to help courts in establishing the meaning of legislation. When another of the three basic rules, the literal rule, yields absurd or unclear result, the golden rule is implemented. Lord Winsdale stated in the case of Gray v. Pearson, 1857, quote, "The grammatical and ordinary sense of the word is to be adhered to unless that would lead to some absurdity or repugnance or inconsistency with the rest of the instrument, in which case the grammatical and ordinary sense of the words may be modified so as to avoid absurdity or inconsistency, but no further." Close quote. This indicates that under the golden rule, a judge may stray slightly from the literal meaning of the phrases in order to give respect to the legislative objective and obtain a reasonable ruling. Now, the golden rule can be described in two ways. There are two approaches to this problem, a narrow approach and a broad approach. When wording in the statute can be interpreted in various ways. The narrow approach is used when judges use this limited approach. They are able to interpret statute text in the most straightforward and understandable way. The case of R. V. Allen, 1872, demonstrates a narrow position. The defendant was accused with bigamy under the Persons Act of 1861. The Persons Act of 1861 states that, quote, "Whoever is married shall marry, and any other person during the life of a former husband or wife shall be guilty of bigamy," close quote. So if you apply the other basic rule, which is the literal rule, someone who has once married cannot marry again in the same lifetime. Even if they had a wedding, they would not be considered married under the literal definition. As a result, the judges in the instance adopted the golden rule, concluding that the word marry should be constructed as to undergo a marriage ceremony. This example shows how the golden rule avoid the case from becoming ludicrous. When there is one or more possible interpretation of the statutes and legislation, is when the court takes the broader approach. The courts may change this wording, but they must not vary from the legislation original meaning or intent. The broad approach is used in the case of Adler v. George in 1964. The defendant was charged with obstructing the armed forces in the vicinity of a prohibited place. Under Section 3 of the Official Secrets Act of 1920, the defendant was taken into custody, and according to the literal rule, the defendant was not in the area. However, the judges used the golden rule to broaden the meaning of the term nearby and interpret the phrase differently. This was done to avoid the potential ludicrous effect of applying the literal rule in the case. Oh.
The literal rule is an approach whereby the exact meaning of words used in statutes is taken as it is in accordance with their precise meaning, albeit producing a senseless result. Lord Diplock, in the case of Duport Steele and Sears, 1980, viewed this particular rule in means of where the meaning of the statutory words is plain and unambiguous. It is not, then, for the judges to invent fancied ambiguities as an excuse for failing to give effect to its plain meaning because they consider the consequences for doing so would be inexpedient or even unjust or immoral. Crown and Harris 1836 is a good case that portrays the literal rule in which it was used strictly. The defendant bit off the end of the plaintiff's nose, but was not committed to the offense. This is due to the literal rule where the offense of unlawfully and maliciously stab, cut, or wound any person was interpreted in a precise sense, where the court held that a defendant had not committed the offense because the statute mentioned the use of weapons. A recent case, Crown and McGuinness, 1987, had various interpretation of the Section 5, Subsection 3 of the Misuse of Drugs Act 1971, which provides it is an offense for a person to have a controlled drug in his possession, whether lawfully or not, with intent to supply it to another. The defendant was caught to have a package of cannabis resin in his car, which he intended to return back to his friend. The defendant was convicted and appealed to the court that the intention to return the drug is not considered as supplying Oh no. Yeah. The defendant was caught to have a package of cannabis resin in his car, which he intended to return back to his friend. The defendant was convicted and appealed to the court that the intention to return the drug is considered as supplying. There was a mix of opinion within the judges regarding the definition of supply. In this context, where House of Lords, who mostly adopt the doctrine of literal rule, viewed it as supply due to necessary intent to return the drug back to his friend. However, Lord Gough gave a dissenting judgment whereby he had argued that the offense was aimed at the drug pushers. He believed that the offense should have been lesser as he was not supplying the drugs, but instead an offense of unlawful possession. Therefore, when statutory interpretation is done in the literal rule manner, judgment of cases are concluded objectively. Judgments are strictly made by obeying the literal principle of what is defined in the statutes and is not easily influenced by other personal opinions of judges.
Hello, my name is Hazim and I will be covering mischief rule. So what is the mischief rule? The mischief rule is a lens to which judges use to understand or interpret the law or legislation in the light of mischief or evil to which the statutes seek to address. To have a further understanding of what the mischief rule is, let's take a look at a case law to which the mischief rule was applied. The case of Smith and another v. Hughes. The case involved the Street Offense Act of 1959 under Section 1, Bracket 1. In the context of the case, it involved 1, the solicitor trying to attract the attention of men on the sidewalk to her by tapping on the window pane with a metal object as they passed by in the streets in front of her. 2, having so attracted their attention, to invite them in for a price, which she indicated by extending 3 fingers of her hand and indicating the correct door of her premises. So, how does mischief rule come into play in this case? The sole question here is whether in those circumstances, as I mentioned before, were each appellant soliciting in a street or public place, because the words of the Street Acts are in this form. And I quote, "It shall be an offense for a common prostitute to loiter or solicit in a street or public place for the purpose of prostitution." Lord Parker highlights that the physical location of the solicitation of the prostitute is not the major factor to look at the case. However, the actions of the prostitute on their premises by the window pane that had led to the attention of people walking by the streets being drawn to them is the major factor. So what was the outcome of this case? Well, the court had dismissed their appeal. Why? Lord Parker said, and I quote, "For my part, I am content to base my decision on that ground and that ground alone. I think that the magistrate came to a correct conclusion in each case, and that these appeals should be dismissed."
And I will be talking about the purposive approach. Now, before we dive into this topic, what is the purposive approach? What does it actually mean? It is a method of statutory interpretation which examines the intention behind a statute to determine its meaning. The purposive approach can support the development of judge-made law. Generally, it is seen as a skeleton of the law for judges to flesh out in time. The concept of the purposive approach can also support the development of judge-made law in certain circumstances. In the next slide, how can it support the development of judge-made law? For the first point, it can promote legislative intent. Judges can use this approach to identify broader objectives and policy considerations through enactment of a particular statute. Judges can interpret the law in a manner that aligns with the legislation's purpose. Basically, by giving effect to this intent, judges can interpret the law in a manner that aligns with the legislation's purpose, even if the literal or strict interpretation would lead to a different outcome. This enables judges to contribute to the development of judge-made law consistent with the underlying legislative intent. For the second point, it can also accommodate societal changes. As we all know, society constantly evolves, and the approach allows judges to consider and reflect to adapt to the ever-changing social norms, values of society by focusing on the purpose behind the law rather than its literal wording. This allows judges to adapt the interpretation to meet the demands of contemporary circumstances, thus contributing to development of judge-made law, showing that the law is responsive to societal changes. However, it is important to note that while the purposive approach can support the development of judge-made law, it should essentially be applied with judiciously, of course, but with caution. Judges must respect the strict separation of powers and the role of the legislature in making laws, and their interpretations should not unduly encroach upon the legislative domain. It should be rather used as a tool to understand and give effect to the legislative intent, rather than as a means to create new laws. Hence, its meaning to look at the intent behind a certain statute or legislation to uphold it. Now, moving on to the next slide, which is the famously known as the rape marriage case, where the purposive approach was applied in this case. We look at the facts of the case. The defendant married his wife in 1984. They lived separately. The wife moved her son to live with her parents, and the defendant broke into the wife's parents' home and attempted sexual intercourse where the wife did not consent. The defendant was charged with attempted rape under Section 1, Subsection 1, under the Sexual Offences Act 1976. The issues of the case is the husband, the plaintiff in question, appealed his conviction of attempted rape against the same act. He argued on the grounds that in marital exemption, a husband cannot rape his wife due to the issue of irrevocable consent. How can the purposive approach be applied in this case? Prior to this case, the common law held that a husband could not be found guilty of raping his wife based on the legal concept of marital immunity, which considered a wife to have given irrevocable consent to sexual intercourse within marriage. However, due to ever evolving societal views on marital relationships had evolved, there was growing recognition of the rights and autonomy of women within marriage. The House of Lords applied the purposive approach. They held that the statutory language of the Sexual Offences Act, 1956, did not explicitly exclude husbands from being charged with rape. It should be interpreted in light of the broader purpose of the legislation, which was to protect individuals from non-consensual sexual acts. The court acknowledged that the original purpose of the legislation might have not contemplated marital rape, but it emphasized that the law should be interpreted in a manner that is consistent with evolving social values and the principle of equality. The House of Lords then concluded that the exemption of husbands from the offense of rape was no longer tenable, and held that a husband could be found guilty of raping his wife. Thus, this landmark decision not only abolished the common law rule of marital immunity, but also contributed to the development of judge-made law.
To conclude, in the scope of legal system, the common law system offers the most consistency. The judge-made law system requires judges to think about the feasibility of the decision, which would consequently mean that they are more cautious and just when getting to the result. The history of judge-made law is thick with many layers, and it has polished itself into this consistent system and stable system that we see today.